All right, half a day, and good morning, everyone. Is it my time check? Is it? Okay. Yep. Half a day, and good morning, everyone. My name is Frances Tydeco Gatewood, and I'm the Chief Judge of the District Court of Guam. On behalf of our court, Judge Matabusa is not here, unfortunately, he's off island, but on behalf of Judge Matabusa and myself, the District Court of Guam, the Law Week Planning Committee, we are very, very honored to have a lot of the students here today. First of all, as you know, this is law, it's usually law day, but Guam, we do everything extreme, so it's actually law month. And so we're actually into our second week of celebrating law, the rule of law. And this year's theme is the 14th Amendment, transforming American democracy, as many of you know. Now what we have here is we're very, very honored to have our panelists. We have the very esteemed President of the University of Guam and Congressman Robert Underwood. Thank you, sir, for being here. We have Attorney Robert Klitzkie, and then we also have Attorney Aguigui. Their biographical information will be expounded upon by our panelist moderator. And then we also have Attorney Minakshi Hemlani, who will be the panel moderator for today. I just wanted to take this opportunity to thank Professors Ron Uggan, Professors Frank Ishizaki, Professors Ron McNinch, and Professor Pete Seguenza, former Chief Justice, and their teacher assistants who helped coordinate class participation. Kimberly Dela Cruz, is she here, Kimberly? Yes, thank you, Kimberly. Leo Legato, thank you, Leo. And Miss Athena McNinch. I know she's here, I saw her earlier. All right. And also, and that's from the university. And then I also would like to thank 34th Guam Legislature, Mr. Alerta, the Executive Director, congratulations, and who helped coordinate the participation of the Youth Congress who are here. So we are very honored to have you, and the members of the Law Week Committee are also present. So at this time, I will introduce Ms. Hemlani, and she will then tell you how it's going to go today. So thank you and for being here. We hope you enjoyed today's 14th Amendment presentation.
Thank you, Your Honor. Good morning, everyone. Thank you for being here. As the Chief Judge mentioned, this is part of our Law Week celebrations, and particularly for our theme this year, which is about the 14th Amendment, transforming American democracy. The Chief Judge introduced some of our panelists briefly, but I'll read their biographies as well so you can have a little more idea of their history and background, because that'll be relevant when they're expressing their opinions today about the questions that we pose. I'll start at the center. Oh. Attorney Ignacio Aguigui is an attorney in private practice and is a member of the Guam and California Bar. He began his legal career in San Francisco as an attorney at the international law firm of Morrison & Forster and has been practicing law for almost 20 years. He is the founder and principal of the law offices of Ignacio Aguigui, a professional corporation. His law practice focuses on complex civil matters, including corporate and business litigation and transactions, class actions, government law, and constitutional law. He was and currently is legal counsel of record in major high-profile cases, including the Guam tax refund litigation and litigation involving ancestral property rights, where the principles of due process and equal protection have been litigated. Mr. Aguigui is a son of Southern Guam. He grew up in Maritzo, graduated valedictorian from Inarajan High School in 1987, and earned his Bachelor's of Arts at Yale University with honors magna cum laude, and his Juris Doctor degree with honors from the Columbia Law School in New York City, where he was a Harlan Fiske Stone Scholar. He's been awarded prizes and research fellowship for study at the University of California at Berkeley and the University of California at San Francisco, has studied French law and European community law at the University of Paris, and held various government of Guam positions, including Special Assistant to the Governor and Chief Legal Counsel to the Governor. And he continues to serve on various board of directors, including the Guam Election Commission, the Guam Public Library Board, and Guam Legal Services Corporation. Welcome, Attorney
Thank you. Thank you. Thank you, everybody.
On our left is President and Dr. Underwood. Robert Underwood is a former member of the U.S. Congress and is currently the president of the University of Guam. Some of you may know him. I think some of his students are here. As a lifelong teacher, he has served as a high school teacher, curriculum writer, administrator, dean of the College of Education, and academic vice president. He is a distinguished scholar with many publications on education, regional political issues, indigenous concerns, and cultural change. He served as a congressional delegate from Guam in the 103 through 107th Congresses, that's 1993 through 2003, during which he sponsored major legislation for Guam, played an active role in Department of Defense authorization bills, and was a forceful advocate for political development for insular areas. He was an original member of the Organization of People for Indigenous Rights, appeared before the United Nations in 1982, led the fight against the Guam Constitution in 1979, and was a community organizer in the 1970s and 1980s by organizing demonstrations, petition drives, and raising as much hell as he could legally. Welcome, Dr. Underwood. And on our far right, where he requested to sit, as per his ideology, is Mr. Robert Klitzkie. Robert Klitzkie was born in 1938 and has lived on Guam most of his life. He says that he is a quote-unquote recovering lawyer and has a serial has-been. And I have a footnote to what his has-beens have been. He's teacher, legislative counsel, minority counsel, police legal advisor, director of corrections, director of education, general manager, radio newscaster, TV talk show host, radio talk show host, senator, and judge pro tempore. According to Bob, he brings a textualist or originalist approach to the constitutional interpretation. He holds that the living Constitution approach is really just an exercise in judicial realism in the extreme, and if given a choice, a strict constructionist bent trumps a liberal one for Mr. Klitzkie. Mr. Klitzkie submits that the right result reached by the wrong means is the foundation for the quote-unquote doctrine of unintended consequences. Welcome, Mr. Klitzkie.
Thanks.
So the organization of how we'll conduct the panel today is we've constructed a number of questions, and we'll see if we get through all three of them. But what we want to begin with is some background questions regarding the 14th Amendment. Then we'll continue into some of the current issues and the interpretation of that amendment in today's context. And finally, we'll open the floor to some question and answers from the students to the panelists. Okay? So let me begin. Ready for the first question, John?
I'm ready. I'm ready for anything, Minakshi.
Okay, great.
Yeah.
We'll start with the first question with you, and I'll read it in. The 14th Amendment is often referred to as one of the Reconstruction Amendments. So what are the Reconstruction Amendments, and please explain the historical context of the 14th Amendment.
Thank you. In order to understand the 14th Amendment, it's necessary to understand two others, the 13th and the 15th, one war, the Civil War, and one court case called Dred Scott versus Sanford. I want to start out with the last sentence of the 14th Amendment. We talked about the last sentence of the 14th Amendment, which reads, Congress shall have the power to enforce by appropriate legislation the provisions of this article. That same sentence appears at the end of the 13th Amendment and the 15th Amendment, and I submit that it's the most important part of those. I got an echo here somewhere.
I think you need to move.
Okay.
Let's try that.
The last sentence, is that better? Okay, the last sentence of those three amendments, in a sense, delegates the ability to amend the United States Constitution to Congress, and I'll be coming back to that from time to time today. The court case that I mentioned was a case called Dred Scott versus Sanford. That case held that slaves were not persons, certainly not citizens, and therefore could not sue in the federal courts. If Justice Taney had stopped there, history probably would have turned out quite a bit differently, but he didn't. And as a result of perhaps some of the inflammatory language he used in that decision, that court case, which held that slaves and former slaves were not citizens, in fact, weren't even persons, as the Constitution used that term, That case was never overruled, except that the Civil War and the 13th and 14th and 15th Amendments basically made it of no value at all. The 13th Amendment was the amendment that said there shall be no slavery in any of the states or in the United States, or, and this is also kind of an interesting sentence that we may touch on later on, let's see, or in the United States or any place subject to their jurisdiction. That may or may not be important later on. The 14th Amendment provided for equal protection of the laws and due process of law. The 15th Amendment said that a person could not be stopped from voting because he had been a slave. So those three amendments are the Civil War amendments, and I would submit that anyone who understands what was going on from actually the time the Constitution was enacted, word slavery wasn't used. A couple sections in the Constitution kind of beat around the bush, but slavery is what was involved. Those three amendments were to deal with slavery. One, the 13th Amendment to abolish slavery. Two, the 15th Amendment to make sure that those who had been slaves could vote, and the 14th Amendment with use of the Equal Protection Clause and the Due Process Clause to provide that former slaves had civil rights. That's why the Civil War amendments were adopted, those three amendments, and some would hold that that pretty much should describe the outer boundaries of the effect of those three amendments. However, as I mentioned at the beginning, that last sentence of those three amendments, that Congress shall have the power to enforce by appropriate legislation the provisions of this article, gave Congress almost the ability to amend the Constitution.
Okay, we'll get to that in a minute. Can you tell us exactly what is the 14th Amendment to the Constitution? Just briefly explain the rights that it provides.
Well, it provides for equal protection of the laws and due process of law. Equal protection, I think, probably at the time that the amendment was enacted meant that everybody should get the same kind of protection from the cops, especially when bad people came along. But the word protection has been expanded to the point that it is hard to recognize it anymore because it has now become synonymous with the word benefit. And what that actually means takes you back to that fifth sentence of the amendment. Depends on what Congress says it means. Pursuant to that fifth sentence, Congress having the ability to enforce the Equal Protection Clause created a group of faceless bureaucrats called the Equal Opportunity Commission.
This is the point where I should interject and say that the opinion of the panelists does not reflect that of this court.
Or anybody else, probably.
Probably not. We are going to get into the interpretation of the equal protection and certain language used in the 14th Amendment, but just to briefly outline, due process, equal protection of law, and citizenship.
Yes, yeah.
Okay, so the Bill of Rights was originally bound only the federal government. So how did the 14th Amendment expand those guarantees to state and local government? Okay,
question is, how did the 14th Amendment expand the protections of the Bill of Rights, such as they are, to the states when the Bill of Rights were primarily enacted as a restriction against the federal government? And the answer is that the 14th Amendment didn't. It was the Supreme Court of the United States, through a case called Gitlow versus New York, one paragraph in that case that said that the due process and equal protection clauses of the 14th Amendment should really selectively incorporate parts of the Bill of Rights into their own force.
Do you agree with that, Mr. Aguigui?
Well, maybe Bob, it would help for the benefit of the audience here to maybe go into what the Bill of Rights
Feel free.
really,
If you think that'll help your response, then please, for the benefit of our audience. Please.
Okay. Well, the Bill of Rights are generally considered the first through the 10th Amendments, and those were enacted prior to the 13th and 14th and 15th Amendments. And so those amendments concern things like the freedom of expression, the right to freedom of religion, freedom of the press, freedom of speech. And so historically what happened is those amendments were enacted with a view of guaranteeing those rights and ensuring that the federal government didn't go beyond the scope of their powers to intrude on these rights that were guaranteed and reserved to the people. And so what I think you are referring to later on, which is the doctrine of incorporation, is the courts at that time interpreted the 14th Amendment, specifically the Due Process Clause and the Equal Protection Clause, to incorporate those same protections in the 1st through 10th Amendments. And some of them, I believe, one or two of them haven't been incorporated into the Due Process Clause. But those were incorporated into the 14th Amendment to apply to the states. Because, as we know, in our government system, we have several layers. We have the federal government, we have the state governments, and also, as probably we'll get to talking about later today, the territorial governments, as I think Dr. Underwood will touch upon later.
Right, and I think the particular sentence that you're referring to in the 14th Amendment is the one that begins, "No state shall make or enforce any law which shall abridge the privileges and immunities of the citizens of the United States." So that's the reference that the 14th Amendment makes to incorporate the Bill of Rights to states. The question is it applicable to Guam? And I'll direct this question to Dr. Underwood. The original 1950s Organic Act's Bill of Rights is silent as to the applicability of the 14th Amendment to Guam. In 1968, the following language was added to the Organic Act Bill of Rights, and I'll read that language that was added in. It said, "The following provisions of and amendments to the Constitution of the United States are hereby extended to Guam to the extent that they had not been previously extended to the territory, and shall have the same force and effect there as in the United States or in any state of the United States." So, Dr. Under, what's the significance of adding this language to the Organic Act of Guam in 1968?
Well, there's half a day. I tried to read on the internet this morning how to talk to a lawyer, since I'm the only one that's not a lawyer up there. So it said, be very careful.
It's recorded.
It's very significant because even though most of the discussion today and most of the discussion across the country about the 14th Amendment will be about the entire application of the 14th Amendment, the 14th Amendment is only selectively applied to Guam and the territories. And so the first sentence in Section 1 of the 14th Amendment is all persons born or naturalized in the United States and subject to the jurisdiction thereof are citizens of the United States and of the state wherein they reside. So that sentence is eliminated, and we just start with the second sentence as indicated there. This has an historical background. This was first proposed by Patsy Mink in 1968, and the thinking then was to try to extend the kind of basic civil rights, kind of personal rights of expression and civil rights and equal protection of the law against the federal government as encroached on by the federal government and encroached on by the local government, the government of Guam, to extend it to the people of Guam. And she had proposed extending the entire 14th Amendment to Guam. Well, the objection came from the Department of Interior and the Department of Justice at that time, that by doing so, you're actually kind of changing the political status of Guam and moving it away from unincorporated territory. And by doing so, you then kind of change the political standing of the territory, and you also, kind of cloud the issue on Section 2 of the 14th Amendment, which talks about representation. And so that's kind of a different kind of right of citizenship, which is your political representation and your level of participation in the decisions of the country. So in order to avoid all those issues, it was recommended that only the second sentence be applied, and that's where we stand today. So basically, on the basis of this, there's an argument. It's a live argument, although it's, in some respects, it's a theoretical argument, that there's a distinction between the kinds of citizens that are created out of the territories as kind of statutory citizenship, and then you have constitutional citizenship. And the constitutional citizenship you kind of carry with you wherever you go, and statutory citizenship, theoretically, Congress could take it away. Now, in practical terms, that's not going to happen, and there are many people who argue that that distinction no longer obtains. But if you'll notice that in the case that Neil Weir is presenting, We the People, the basis of that is to declare that this kind of natural-born citizenship applies to the territories. So what that means essentially is that it opens up the question, if that's the case, then your rights as a citizen, in terms of like our basic rights here, as argued upon by attorneys in various cases, and the application of this section of the 14th Amendment, means that basically our personal civil rights are pretty much intact, you know, and coming right out of the application of this sentence of the 14th Amendment, the first case on that was on Guam was Meyer versus Slotnick, and that was a case involving the giving scholarships by the government of Guam at the University of Guam. And at that time, the government of Guam said that you couldn't give scholarships to non-residents and that military personnel were non-residents. So immediately that person took the government of Guam to court on the basis of this application, and therefore thereby changed the rules of the government of Guam. They could no longer do that. So it had almost immediate application. But that was kind of like your personal relationship with the government.
Right, and I think you answered my next question, but I'll pose it just the same, that the significance of U.S. citizenship for people of Guam, because it arises from the Organic Act as opposed to the Constitution. Is that what you were saying with regards to statutory citizenship?
Yes. Yeah, and you know, the notion of statutory citizenship and constitutional citizenship was been raised by a number of attorneys, and it continues to be an issue. And so some people argue that if you became a citizen of the United States via the Organic Act or via some statutory authority like that, that the Congress could, this is not theory, I think it's absolutely true, Congress could withdraw that authority to make future citizens in the territory of Guam. Whether or not they can take away anybody's citizenship is an entirely different issue. I don't think that's practical, and I don't think anybody is thinking that way. But it does open the question of whether citizenship is the same, or is it differentiated? And if there's differentiated citizenship, that's the basis upon which your political rights, your rights to representation, core American creed, going back to the Declaration of Independence, is that all men are created equal and they're endowed by their Creator with certain inalienable rights. And these are self-evident truths. You don't have to prove them. They come from natural law. These are self-evident truths that all men are created equal and that they are entitled to form and constitute a government based on the consent of the governed. That's the core American principle, and that's violated every day in Guam and the territories.
Okay, I think Mr. Klitzkie has a response to that.
Yeah, I do. The only place that really counts that citizenship is mentioned in the Constitution or its amendments is in the 14th Amendment. And that provision, of course, says if you're born in the United States, you're a citizen of the United States and the state in which you were born. But if Robert is correct, then those people born in Germany of two U.S. citizen parents are statutory citizens, and Congress could theoretically take their citizenship away from them. That just isn't the way it is. No, I don't want to go into a lot of case law, et cetera, but there's a case called Ephraim versus Rusk that's 35 years old or so that pretty much says that citizenship is indelible. Once you got it, you can't lose it. And one small exception, maybe if you were a guard at Auschwitz and you filed false naturalization papers, maybe you could. But other than that, No, so the dichotomy between statutory citizenship and constitutional citizenship is more illusory than real, because the only constitutional citizens are those born in the United States. So under that particular rubric, even Abraham Lincoln was a statutory citizen because he was born before the 14th Amendment was adopted. I got a lot more to say, but I can tell.
No, that's absolutely false. It's absolutely false, because Congress never tried to pass a statute about passing citizenship for people born of U.S. citizens inside Germany. But they did pass it for the territories.
They did for...
That's the issue. That's the issue in front of us on the statutory citizenship. Now, that's a theory of statutory citizenship. In practical terms and in subsequent legislation and the application of INA laws and so on, and naturalization laws, this has been further defined so that the likelihood of anyone's citizenship being taken away is remote. Now, Puerto Rican nationalists tried to test this out by going to a foreign country like the Dominican Republic or Venezuela and saying, I hereby decide that I'm no longer a U.S. citizen, and then go to the embassy and declare this, which you can do, and then therefore they will be non-U.S. citizens. Then they went back to Puerto Rico and they tried to enforce this, and the district court and the federal courts wouldn't allow them to do this. So that seems to indicate that once they've made you a citizen, they can't take it away, but they can make rules and regulations about where citizens are developed. And that's the quandary, I think, where territories are, because American Samoa, that's the issue. In American Samoa, it's a U.S. territory. Citizenship is not automatic when you're born.
Well, Dr. Underwood, it's a whole nother level of discussion about the type of citizenship that we have in the territories. And I'm going to touch on birth, tourism, and citizenship under the 14th Amendment a little later. But I want to go back to what you said about our inalienable rights under the Declaration of Independence and what we consider fundamental rights in the United States. The next question I'll direct it to Mr. Aguigui, but I'm sure you all have comments. The U.S. Supreme Court has expanded equal protection and the interpretation of fundamental rights. For example, a number of fundamental rights protected by the 14th Amendment, such as the right to marry, the right to privacy, and the right to use contraception, do not appear in the text of the U.S. Constitution. And some argue that the Reconstruction Amendments address only slavery and should not be construed to apply beyond that. So what are your thoughts on that?
Well, I guess my short answer to that is it's a view that's been espoused and it's a view that's been argued, but it's never been the case. It's never been the state of the law in how the Supreme Court of the United States has interpreted the Due Process Clause. If you look at the text of the Due Process Clause, it says that no state shall deprive any person of life, liberty, or property without the due process of law. So to understand how this works, or at least how the courts have interpreted this, courts have looked at this as having both a procedural due process component and a substantive due process component. So procedural due process component, which I'll touch upon lightly, basically says that if the government's going to go ahead and deprive a person of life, liberty, or property, they have to follow certain procedural safeguards. And that's kind of a discussion for another day. But the substantive due process component, which the Supreme Court of the United States and also the federal courts have interpreted throughout the years, at least for over 100 years, says that there are certain really fundamental rights that are, first of all, it begins with the Bill of Rights, certain protections there, for example, the freedom of the press, the freedom of association. That are protected in there, and those are guaranteed to citizens and should be protected from government interference and from government's infringement of those rights. If we're looking at these fundamental rights that have been developed recently, for example, in the Obergefell case, which basically nationalized and struck down all the state laws nationwide that have infringed on the right of same-sex couples to marry, I think the courts have looked at and expanded upon this concept of liberty in the Constitution. And the courts have said, the federal courts and the Supreme Court has said that, look, there's a fundamental component that's inherent in the Constitution. It says that an individual's right to liberty must be protected, and any government's infringement on those rights have to be viewed with circumspection. So as a result of that, there have been other decisions that have, prior to Obergefell, there have been other court decisions which have expanded on this, it's called a penumbra of rights, that focused on the person's individual liberties. So those are part of the core of decisions of the Supreme Court and the federal courts, which have developed around these set of rights that have been protected by the federal courts.
Mr. Klitzkie, do you have a response to the development of fundamental rights through the Supreme Court?
I do. As a matter of fact, I do. What a coincidence, right? Yeah, Minakshi mentioned in the beginning that I'm a strict constructionist, and part of that is what is called the doctrine of legal realism. And simply put, the doctrine of legal realism is that judges, especially Supreme Court judges, figure out how they want a case to turn out. And after they figured out how they want it to turn out based on their education, background, upbringing, society, what they had for breakfast, all these important things, they then go through various statutes and cases and find language that describes the result that they want to reach, pretending all the while that they use that tool of analysis to reach the result. And a really good example is the so-called right to birth control. Well, there's no constitutional right to birth control, and there's no Supreme Court case that holds that there's a constitutional right to birth control. There are lots of acts. There are acts of Congress that say that people have the right to have the government pay for it, and that you may have the right to pay for it. But there was a case called Griswold versus Connecticut that found that there is a right of privacy, and that right of privacy was so extensive that it could not be used to prohibit the provision of birth control devices in the state of Connecticut. So some Supreme Court judges have justices have magic glasses. They can read things that aren't even there.
Well, in the United States, fundamental rights are groups of rights that have been recognized by the Supreme Court as requiring a high degree of protection from governmental encroachment. And that's, as Mr. Aguigui said.
Well, if I could just one more minute on Griswold,
I am going to let you continue. I just want to put this basis to say the fundamental rights in the United States are either those recognized in the Bill of Rights or they're developed through due process. And the right of contraception that you mentioned comes through the right of privacy, as you said. So So the Griswold versus Connecticut case said that that the right of privacy in the Bill of Rights was what protected people's or prohibited the state from banning the sale of contraceptives. Now, justices have magic glasses that allow them to read words that aren't even there, because you look through the 10 amendments, you won't find. In fact, you look through the whole Constitution, and you will not find the word privacy anywhere. But it was determined that somewhere in the penumbra, there's a word to write down in Google when you get back to school. Somewhere in the penumbra of the Bill of Rights, there is a right of privacy. But on the other side, other justices are so nearsighted that they can't read words that are right in front of them in the Constitution. For instance, the darling of the conservatives, Mr. Justice Antonin Scalia, may he rest in peace, could read the Second Amendment, but couldn't find the word militia in there anywhere. So I'm done. No, I'm sure you're not. Just to continue on that vein, there's an argument that terms found in the Constitution or the 14th Amendment, such as liberty, equality, privileges, and immunity, they don't have a fixed content, and they're continually defined in a set of new facts as things evolve in our society, and things we could not have anticipated. Dr. Underwood, I know you have some thoughts.
Well, yes, I think it's obvious that, and I'm glad to report that Obergefell was our commencement speaker at the university a couple of years ago, so just wanted to point that out. the changing nature of society and the relationship to the constitutional framework is one that's always going to create tensions and redefinitions. And so while it seems pretty obvious, and I always tell young people that when we were going to school, we saw pictures of the Constitutional Convention and people in Philadelphia in the Declaration of Independence, and then we were always told that those were our forefathers. Our forefathers, and I kept saying, is that really my forefather? Is that really who I am? And I'm trying to find this line of connection. Of course, the line of connection is not ancestry or being descendant from them. It's really about a set of ideas and principles that you live. You live these principles in present-day realities, and every generation is commanded to analyze that for themselves and to make their contribution. Now, we can minimize that, and we can trivialize it by saying, well, a Supreme Court justice got up this morning and he decided to have a certain kind of breakfast, and therefore this influences decision on that. But in reality, these are very weighty topics, and the notion of privacy, the notion of what is cruel and unusual punishment, what is the right, and I think Bob Klitzkie and I agree on the meaning of the Second Amendment, what is the right to own a weapon, all these kinds of things that are kind of interpreted in the context of our present-day lived realities, because the spiritual or historical forefathers that presented the Constitution as the framework couldn't have imagined the kind of technological changes that we're experiencing, couldn't have imagined what elements of birth control existed, couldn't have imagined what kind of genomic studies we're doing today, couldn't have imagined that we could predict with any certainty whether we're going to have a male or a female as a child and what is the level of intelligence that individual will have. These are all kinds of challenges to our notions of privacy and control and our relationship to the state. Those have to be revisited periodically, and I think that puts me on the side of the living document. But I don't like to think of it as a living document. I like to think of it as a document applied to lived experience, and that's what we have to go through, and each generation is commanded to do that. So you can't just sit around and say, well, it's already been decided. You're commanded to do that. You're supposed to think about it. You're supposed to get over there, and you're supposed to get out and engage. You're supposed to find out why only parts of the 14th Amendment apply to the territories. These are issues that command your attention and command your action.
Well, Mr. Aguigui, what's your thoughts that the 14th Amendment is written at a higher level and is not just applicable to slavery during the Reconstruction era, and is frankly where I stand on this, a framework to argue rights in new contexts?
No, I think it's true, and I'm sort of following up where Dr. Underwood left off, which is that perhaps the debate around whether this construction that Mr. Klitzkie alluded to, which is that the Supreme Court and the courts are developing these rights as they wake up each day, and they're creating new rights from week to week or month to month. I think the argument has probably been misguided in a sense, because, for example, in the cases, in the Griswold case, which he spoke about, which where the Supreme Court struck down laws in Connecticut that prohibited anybody actually from doing anything to promote contraception. And in that case, the court said, picking up on the right to privacy, which really isn't what we would normally think of as a right to privacy. It's more a right to personal autonomy, to decide for ourselves how are we going to make these decisions about whether to procreate, not to procreate, to avail ourselves of what the medical technology or the medical devices or medical science and research has at our disposal at that particular time, to make decisions about whether or not we can avail ourselves of these developments of modern society. So I think, analyzed that way, it's not all that difficult to appreciate how the jurisprudence, and when I speak of jurisprudence, I'm talking about really the case law It's a distinguishing feature of American law and Anglo-Saxon law. It's called the common law, and this is distinguishable from other countries which have adopted a different legal system, such as the civil law. In common law jurisdictions, which are based really on the laws of Europe and the system in Europe, judges create a body of decisions that interpret statutes, that interpret regulations, that interpret the Constitution. And this body of decisions itself creates a body of law that has to be respected and has to be followed by the other branches of government. And this also goes to the concept of separation of powers, right, that we all learn about in civics class and government class, which is each branch of the government is co-equal, but they also have a particular role, but they're also powerful. And the role of the courts in this tripartite system of government, which is also based in, historically on the writings of people like Montesquieu and all these philosophers, John Locke. It commands that the decisions and how judges interpret the law has to be respected by the executive branch and also the legislative branch. So when we're talking about decisions like Griswold, which says that, look, there's this right of personal autonomy, and the state of Connecticut's infringement on that right of personal autonomy to decide and criminalize, actually, it's kind of incredible for us to imagine at this point, right, in the 21st century, where at some point in the past, states had actually made it a criminal act to help somebody or give out condoms or give out birth control or see your doctor and have your doctor prescribe methods of birth control. That's actually what was at issue in Griswold. Is one of these doctors at a medical school actually was counseling a couple on how to employ these different methods of contraception, and criminal charges were brought against him by the state. And so this case went all the way up to the Supreme Court, and they won.
I know. Sorry, I'm going to switch gears just a little because I saw Mr. Klitzkie flinch a little bit when Dr. Underwood mentioned the living document. So I'll let him respond.
Thank you very much. Yeah. The constitutional interpretation that relies on the Constitution as opposed to what's popular today goes back to either originalism or textualism. And please don't ask me what the difference is, because I can never remember, but I like them both. As opposed to an approach that says, well, society changes, so we've got to kind of dump some of the principles that we thought were really important before and adopt some new principles. So what we have, according to my understanding of the theory of legal realism, is here's a second new word for today: critarchy. Critarchy means rule by judges. So what we have now, we don't have rule by elected representatives. We have government by judges, and no matter what the Congress does or what state legislatures do, 5 folks in black robes can overrule them and determine what the law of the land is. I see this as dangerous, and as I see it, as taking us down the wrong road more often than not. If nothing else, the doctrine of large numbers tells us that most of the time the people are going to get it right, and a small minority runs a great risk of getting it wrong. I'll give you 2 good examples. One is that Lochner versus New York, a case which was so far to the right that even conservatives don't like it anymore, announced the fundamental right of liberty of contract. And another case is really important because it held that the Constitution followed the flag, and that the right to own any kind of property, even if that property happened to be another human being, was a fundamental right. That's Dred Scott that we talked about a little bit earlier. So I see that as erratic as a democratic form of government can be from time to time, it's far less dangerous than government by judges or critarchy.
It's almost as if you're suggesting, Mr. Klitzkie, that we should be quicker to follow policy and government created by politicians than by judges.
Well, I think what he's really suggesting is that
Was that addressed to me?
It was just a comment.
I think what you're suggesting, Bob, is that the decisions of the majority are always correct. Is that necessarily true?
I would say that given the mechanism that we've created, this kind of Rule Goldberg device, with 3 different branches over here, all of them having different functions, and then states that operate in a different direction, it goes right back to what Thomas Jefferson said. You know, he started out with the proposition that man is man and human nature is never going to change. So in order for a system to function, we must match interest against interest and not give too much power to any particular person or branch, which is what we have right now, because 5 people in black robes have more power than the legislatures of the states or the Congress of the United States, even the president, even President Trump.
You sure about that? We're just going to let that lie.
No, I sort of have something to say on that. I think that, you know, his view has been espoused, but I think that, you know, I would almost say thank God for the courts, really, because the courts have really been the defenders of individual liberties. I mean, without decisions such as Brown versus Board of Education. I mean, you know, in those days when Brown was decided, and if you know, for those of you who don't know, at that time the schools were segregated. Actually, you know, black people couldn't attend schools that white people were attending, and that was the law of the land. You know, one of the other decisions that I was going to get to was the decision of Loving versus Virginia, which actually made it a criminal act to marry somebody of a different race. Can you imagine that? And those laws, if we had depended upon the wisdom of the majority in those days, would probably still be in the books. I don't know. I mean, you know, history is always 20/20 in hindsight, but if it hadn't been for the courts, I believe, interpreting the Constitution and the laws as a living, breathing kind of progression of legal concepts and rights, I think we wouldn't be in the position that we are right now, where you know, a lot of laws that have infringed on the rights of people to really exercise and to enjoy the benefits of being an American and living in the U.S. Have been respected.
Let me let Mr. Klitzkie respond to that.
Yeah,
I'm going to go to another question.
I would just mention 2 cases to highlight the wisdom of the courts and the court's willingness to protect individual rights. One is Kobayashi versus the United States, and the other is Hirabayashi versus the United States. Those are 2 Supreme Court cases decided in 1947 that held that rounding up United States citizens of Japanese ancestry and hauling them off to concentration camps was constitutional. That's your judicial protection of individual rights. Thank you.
Well,
Turn back to the 14th Amendment.
Yeah, but you know the whole issue of how you'd have to kind of calculate how many laws go before courts and how many practices go before courts. You know, and unless I'm kind of misunderstanding it, of course we see some high-profile ones, but the courts are not legislative bodies. They're not meant to be legislative bodies. So I don't think they're legislating. I think they're making decisions based upon certain principles that are in case, as in the case of the 14th Amendment, equal protection of the laws. And so as you try to fashion a system of government and you try to analyze what those laws are that may run afoul of that, you have to judge it in terms of a lived experience. Somebody is having an experience. So it's not like we're just making it up as we go along. Somebody is having an experience which they think some basic principle is at stake. And through that process of judicial review, that determination is made. And at the end of the day, yes, it's 5 people in black robes that actually make the final call. But even before you get there, it's still a long, complicated process. So, and that live debate, that that checks and balance, that ability to, I take comfort in the fact that there are judges who are willing to make a determination about an executive order from the president. I don't see that as overreach. I take comfort of that. And I want to advertise that the Attorney General of the state of Hawaii, who took that case to court in Honolulu, and for which Attorney General Sessions said, somebody out in the middle of the Pacific can just make a decision. That Attorney General, Doug Chin, is going to be our commencement speaker at the university on May 21st. So I'm trying to kind of constantly try to figure out how this dynamic is at work and how it's lived in our society. This is about lived experiences, and this is about experiences that are then applied to principles. And while there is, on occasion, judicial overreach, we had to go through the security today, so that's a little bit of overreach. But other than that, we're in safe territory.
Well, Dr. Underwood, you mentioned a little bit about President Trump's travel ban, so that brings me to another question. So the 14th Amendment extends rights of due process and equal protection of the law to non-citizens who are present within the United States. Do you think those same protections to be extended to non-citizens trying to enter the country? For example, those who may be affected by President Trump's travel ban?
I don't think non-citizens in that situation have constitutional rights, but I think Congress has a right to regulate how that process is handled. So my understanding is that in this instance there are laws in place which even though the president has a right to ban travel and from certain countries, he can't do so just willy-nilly. He has to provide evidence of it, and he has to demonstrate that this is not carried out on the basis of some kind of ordinary prescription, like your place of birth, or you just can't get up tomorrow morning and say, I've decided that nobody who was born in the Philippines can come to the U.S. It just doesn't work that way. And so it's the same thing.
Wouldn't that be the same analysis that the courts use when trying to determine if the government is encroaching on people's fundamental rights? The question is, is there a compelling purpose? Is there a process narrowly tailored to that compelling purpose? It almost sounds as if they are extending those rights to non-citizens trying to enter the country. Mr. Klitzkie?
Yeah. First of all, I would like to speak for a moment in defense of Mr. Jefferson Beauregard Sessions, if that would be okay.
Just a moment.
Right. So the way the law works is this: if you are able to acquire jurisdiction over the United States in the District Court of Hawaii, you could get a TRO that binds the entire United States government, literally in a day or two. That's the way it works. Now, if that case finally gets up to the Ninth Circuit and the Ninth Circuit decides on a point of law, that is only binding on 11 of the Western states. But a district court judge has tremendous power in a properly joined case. And that's what Mr. Jefferson Beauregard Sessions was trying to say. And believe it or not, sometimes lawyers will overstate their case. They will exaggerate a little bit to make their point very clear. Now, people jumped on that like a duck on a June bug when it appeared that he was dissing the good folks in Hawaii. But what he was really trying to say is the president has almost unfettered authority when it comes to immigration. Certainly Congress does, and unfortunately, we've done that one with the Philippines. We have had statutes on our books that said no Chinese, no Japanese, etc. So when you're standing in line at the consulate in a foreign country, you don't have any constitutional rights. The president and the Congress do. The courts almost have no role. There's no constitutional application. But what happened in the Hawaii case was, first of all, states can't bring these actions on behalf of their citizens, parents patria. That's been the law since the 1920s. So Sessions is just saying, one judge and a faraway island can tie up the whole United States in an area where the president actually has almost complete discretion. That's what that one was all about.
Dr. Underwood?
Well, I think the word is almost complete discretion. That's the key word. He doesn't have complete discretion. He has almost complete discretion. And so in this instance, you know, I don't think the Attorney General, I'm not taking any umbrage at the fact that that he characterized that somebody in the middle of the Pacific can make this determination and gum up the works, so to speak. I don't take any umbrage on that, but I just think that this particular, as I understand it, even in the testimony given by Sally Yates the other day, when Senator Ted Cruz was asking her, you know, doesn't the president have this complete authority on immigration and the management of aliens coming into the U.S., and he proceeded to read the statute to her, and she said yes, but that has been further refined by other statutes, which says that you can't do that on the basis of place of birth, and you can't do that just arbitrarily. And so that, I think, that has led to the trying to figure out to what extent does President Trump's executive order run afoul of that. So yes, you know, I don't think that aliens have constitutional rights in the same way that U.S. citizens have, but there are some kind of like basic principles that are supposed to guide our public officials. It's not about extending rights to somebody else. It's like, what is our appropriate behavior? When is it are we going over the top? When is it that we are exercising our authority in a way that goes beyond our authority? I think that's what's at stake, and I think that's the case that will eventually be, you know, further litigated.
It's real short.
Briefly.
I'm going to reverse myself here and say absolute discretion, and I would point to the case of a gentleman named Al-Waki, who was a United States citizen who was assassinated during the time that he was in a foreign country by order of President Obama. So if you can do that, that pretty much means your discretion is you know, lawyers tend to hedge their bets a little bit. I got to break myself of that habit.
Well, take up his case. Wow.
I think I just want to add something. I think the issues that are being litigated in those cases, the so-called immigration ban cases, are really two things. It's the existence of the president's executive order, and I think the courts right now are deciding on, although preliminarily the district court judges have decided that there is an issue there about the unfettered discretion of the president to make these decisions concerning immigration and who's allowed to come into the United States. They've alluded to limitations on that based on, and what we're talking about here are the Bill of Rights, the Establishment Clause. I think that's one of the arguments that are being put forward there is that, based on the statements that were made, that the motivating purpose behind the executive order was the discrimination against a group of people based on their religion. So, I think that these issues are still playing out definitely in terms of going through the appellate courts, the Court of Appeals. But those, I think, are examples of how issues like this continue to play out. That there are no clear answers in many decades and many years of litigating these concepts, and it's still an evolving concept.
Well, you spoke of immigration, so I have one final question that I'll direct to you, and then we'll open the floor for questions from the students. The Northern Marianas has suggested to the U.S. Department of Homeland Security that the officials considered airline pre-screening of inbound passengers to the NMI to be sure they are entering the Northern Marianas as tourists or for an other legitimate purpose, not to give birth. And the reason is that the birth rate among Chinese tourists in Saipan grew from a handful to nearly 300 between 2010 and 2012, according to news reports. So the final question is, do you think the citizenship clause of the 14th Amendment has been misinterpreted to encourage birth tourism? I'll direct it to Mr. Aguigui, but okay, he's passing. Either of you.
Okay.
Go ahead.
Okay, yeah. It takes you back to that sentence that I suggested was so important at the beginning of our program here, and that is the last sentence of the 14th Amendment. Congress shall have power to enforce by appropriate legislation the provisions of this article. And the key here is all persons born in the United States. So Congress has the ability to enforce that by appropriate legislation. We we have proceeded on the basis that anybody who's born in the United States is a citizen by birth. Back in the days when I lived in New Mexico, there was a guy named Gabe Nava whose mother was 9 months and 1 day pregnant, and she came across the bridge from Juarez into El Paso, and although she hadn't been inspected, she was so close to giving birth, they hustled her through and got her to the hospital. So Gabe Nava was born in New Mexico. He turned out to be one of the best basketball players that the University of New Mexico ever had. So this is one of those cases where perhaps doing things for the wrong reason does lead to the right result. But we've proceeded on the basis that that's all there is to it. But there's only one case that even arguably speaks to the rules and regulations, or et cetera, the breadth of birthright citizenship under the 14th Amendment. That's a case called Plyler versus Doe, which was decided in 1982. And footnote number 10 of that case says no plausible distinction with respect to 14th Amendment jurisdiction can be drawn between resident aliens and those whose entry in the United States was lawful, and resident aliens whose entry was unlawful. That's it. So there is not this abundance of case law that holds that if you were born in the United States, no matter what, you are a citizen. And I think that there's a very good chance that carefully worded legislation pursuant to the fifth clause of the 14th Amendment could say that if your mother was here legally, then you were a citizen. If your mother wasn't here legally, then you ain't a citizen. I think that's what the law is. I think that's what the law could be. But if I could be permitted to pronounce what I think the law should be, would that be okay?
You can do that. I'll have Dr. Underwood respond.
Yeah.
Okay, I think the law should be just as it is right now. If you're here, if you're born here, you are a United States citizen. It doesn't matter if you came in on a hang glider. Your mother came in on a hang glider. You are still a United States citizen. And I don't say that from any great ideological standpoint. I say it from the standpoint that it's in important matters, bright line rules and black letter law are much safer from the machinations of politicians and judges than those that leave any wiggle room whatsoever.
Dr. Underwood?
Not to respond directly, but just to make the point again, going back to the omission of the first sentence of the 14th Amendment in its application to Guam, which is, all persons born and naturalized in the United States and subject to the jurisdiction thereof are citizens of the United States and of the state wherein they reside. Since that was omitted in the case of Guam, the assumption is that there's a kind of a statutory nature of citizenship here in Guam. And so Congress can be free to move that around for territories. So in this instance, I think Bob Klitzkie is absolutely correct. Congress could pass a law that bans birth rate. Finally he made it. It could pass a law that says that birthright citizenship is denied throughout the entire country. They could do that. That's not likely to happen, but they could do that. Or they could alternatively pass a law that says birthright citizenship is not allowed in the territories, is not allowed in the Northern Marianas, and not allowed in Guam. But they could not say birthright citizenship is not allowed in California or Hawaii. They could isolate the territories for that purpose. Now, the Northern Marianas has to kind of figure out, because this first sentence does apply in the Northern Marianas. So they have a slightly different situation than we do here. The only way that I think that Northern Marianas officials can get out of this is to ask Congress to disallow it for the Northern Marianas. And I don't know that they want to go down that route. But that's where the legislation and the laws that are applicable, I think, are perfectly fit into this particular amendment. But again, it opens up the question of why this distinction is made, so that the birthright citizenship is not just about tourists coming in to have babies in U.S. soil, but actually, what is that distinction that is kind of still unclear about what it means to live in a territory and the nature of birthright citizenship? Now, you know, I never could understand this, and I'll just use myself as a personal example. I was born in Guam in 1948, and that was before the Organic Act. And so, but, you know, it's almost like the right of ancestry. My father, my grandfather came to Guam in 1901, and he came from North Carolina. So his children, all born in Guam, were citizens. And then my father, all his children born in Guam were also made citizens. And I don't know whether that just became, that was through, I don't know, I don't think it was through the application of the 14th Amendment, but it was through some kind of legal process that there was a kind of ancestry right passed along. And of course, my mother was not a U.S. citizen.
Dr. Underwood, I have to interrupt you. Let's open the floor for some questions now.
Okay,
Could
sure.
I just concur especially with Dr. Underwood for a second?
Okay, I do want to leave time for the students.
Okay, I would concur with him on three things. I think probably we're pretty close on birthright citizenship. I applaud his reference to natural rights, and it's good to know that he and I got the Second Amendment right, even though Justice Scalia didn't. Thank you.
All right.
All right. Are there any questions for our panelists? Don't be shy. They have a lot of opinions. Sure, we have one here.
Mr. Alerta.
Thank you guys. Very informative. I really enjoyed it. Just two things. My favorite term used today was personal autonomy, used by Mr. Aguigui. I think that sounds a lot better than privacy. And then, I'm not sure. The part that I caught most was when you guys were talking about how it started off with Senator Klitzkie talking about 5 folks in robes can just wake up, have scrambled eggs for breakfast, and then decide something. And then Mr. Aguigui and President Underwood spoke about, well, I'm not sure if it's that thing. And then Mr. Aguigui mentioned about the majority. Should we always go with the majority? And you're thankful. You said you're thankful for the courts in certain cases, and you brought up Brown versus Board of Education. And then, but you mentioned if we had gone with the majority in that particular instance, that segregation might still be the law of the land today. You said might have been. I don't believe it would have been, or it would be, but I can kind of see both sides of the arguments that you guys presented, because I do think that, and it goes to President Underwood's point about how you have to personally experience these things, and I think our society changes with personal experiences. So if the majority had stayed, if we had gone with the majority for segregation, and would we, I mean, I guess a personal question, do you really think it would be the law of the land today? I mean, I'm sure if we were brought up with, and I say we in general, but if we were brought up with that kind of mindset, would that still be the case? Because I think as much as politicians or judges change the way society behaves, I also think us as society have heavily influenced politicians and judges to kind of shape where we are today. So I'm just thinking, would the mindset still have been segregation is okay, even with the experiences we've gone through since then? And I think it goes back to Senator Klitzkie's Congress or legislators have had an influence on how we behave today, or what we accept as the norms of society.
Can I clarify? I just want to make sure that they have the question correct. So are you asking if
I'm nervous, so I don't. I'm.
Oh, please don't. No.
I think I know what he's alluding
I think
to.
you're trying to ask if the if society is the one that speaks to the legislatures, and the legislatures are supposed to reflect the opinions and the positions of their.
I think it's both the legislators and the courts. I think
Yes,
society.
as well. I will say though that I think the courts are interpreting what the legislators enact, but I'll leave it to the panelists to respond.
Yeah, I think my short question is, I was using it as an example of if the courts had adopted this what's called originalist, strict constructionist view, I think we probably would not have remained in a society where segregation is the norm, but it would have taken much longer, a lot longer. Because I think that politically, the country, and it's difficult for us living in these times to understand what it was like back in the 1950s, but it was completely different from what we would probably know. Okay. Maybe he can speak to his personal experience, after I talk. But I think the courts were very brave at that point. The Supreme Court was very brave to come down and say that, they took this concept of separate but equal, right? And I don't know if Mr. Klitzkie had referenced this, but there was a case that was decided, I believe it was at the turn of the century, called Plessy versus Ferguson. And what happened there is that there were actually railroad cars that were designated for white people and black people. And the case actually came before the Supreme Court, and the Supreme Court said, well, it's okay to do that because they're separate, but they're equal. So you have the same types of cars for white people and black people, and it's okay because they're equal. Well, in Brown versus Board of Education, the Supreme Court rejected that idea and said separate inherently is unequal, at least with regard to schools.
So how does that apply to?
I would be kind of careful to kind of see a direct relationship between all these things, because it's certainly true that social changes provide the framework for how we think and how we experience life. But there's no, the Brown versus Board of Education was preceded by a lot of activity, a whole lot of activity in courts. It wasn't like all of a sudden the light went off and then therefore that changed everybody's thinking. And there was a lot of things going on at the time. And so, the question that we should be asking with Brown versus Board of Education is not that would the segregation have continued. Had it not, had that decision not been made, we should be asking the question is, why did it take so long to get to Brown versus Board of Education? There was something amiss in that. And there might be something that we take for granted in our lived experience now, that 20 years from now people are saying, what were they thinking? Why did they allow this to go on?
Dr. Underwood, you have a good point, because cases don't quickly come to the Supreme Court. They are litigated on lower level courts, and the Supreme Court can decide whether or not to accept a case to decide it. Go ahead.
Yeah, well, Plessy versus Ferguson. By the way, I went to a segregated school at one time.
You come a little closer, thanks.
I went to a segregated school at one time in Miami, Florida, so I have some idea what it's like. But Plessy versus Ferguson was decided in 1896, so it was the courts that gave us separate but equal. Didn't come from the legislative branch, and perhaps outside of the 11 solid democratic states, the solid South, segregation was relatively limited, not completely, but relatively limited. So I again see that the people themselves will reach the right result sooner or later, and generally sooner. And I would also submit, we don't have time for this, that Brown versus Board of Education wasn't the right result. That as a general rule, legislative or popular solutions tend to work a whole lot better than those imposed by the judiciary.
Are there any other questions?
But your question was germane.
Hi, thank you, panelists, for being here today. And this is just I am a student of UOG. This is just one of the questions that we as a class from Professor Uggins' Law Constitutional class have come up with. We would like to ask, why do you think the U.S. Supreme Court resorted to selective incorporation of the Bill of Rights instead of just recognizing specific rights solely on the 14th Amendment due process clause per se?
Yeah. Oh, go ahead.
No, go ahead.
No, after you, sir. Go ahead.
No, I think, and I have a short answer to that, is picking up on what Dr. Underwood said. I think understanding how these cases get to the courts, first of all, is important to understand it, and how these cases get to the Supreme Court. The Supreme Court hears an extremely small number of cases that are coming up from the lower courts. And just to give you an example, let's say a lawsuit is filed challenging a particular government law or regulation. It begins, if it's a federal cause of action, meaning if it involves an issue of the U.S. Constitution or U.S. statute, it begins at the district court level, which is, for example, what this court is, the District Court of Guam. The litigants also have a right to appeal that decision. Most of the time, or actually, in certain types of cases, to the next level, which is the Court of Appeals. And in Guam's case, it goes up to the Ninth Circuit. The litigants, they battle it out. The panel of judges on the Ninth Circuit make a decision there. And then the losing party, oftentimes what they will do is that they have a right to petition the U.S. Supreme Court to hear the case. So it's not a matter of right. The Supreme Court actually has to go through all these, I think it's thousands and thousands of it's called petitions for certiorari. The Supreme Court decides, let's hear it. Let's hear this case. Because, number one, and it could be on the basis of different issues. For example, there's what's called a circuit split. For example, if you have the decision of the Ninth Circuit Court of Appeals and the 11th Circuit, which are on different areas of the nation, there's the same issue that have been decided there, but different results. And so the Supreme Court will hear those cases. So I think what you're asking is the selective incorporation. It's done that because the issues have been put in front of the court in particular factual circumstances and at particular times. So the court doesn't just say, in one particular case, we hereby hold that all of the Bill of Rights are incorporated under the Due Process Clause. It comes up on a case-by-case basis. And to give you an idea about how slow this process is, for better or worse, I guess, is that I believe in 2010 was just the recent decision of the Supreme Court where it incorporated the Second Amendment, the right to bear arms, into the Due Process Clause. So the Supreme Court actually decided that the Second Amendment applies to the state governments. So I don't know if I answered your question, but that's kind of what I would have.
Thank you, Ike. Robert mentioned experience, and much of what we do should be the product of our experience, but our experience is limited to 5 people on the Supreme Court, as opposed to the thousands who sit in state legislatures and U.S. Congress. The Supreme Court, I will withdraw the statement about the importance of breakfast food as far as the ratio decidendi of the Supreme Court is concerned. But it does depend on the experience, et cetera, of the various Supreme Court justices. Right now, we've got 6 Catholics, 3 Jews. Everybody went to Harvard or Yale except one Princetonian. Now, that's a really that's a lot of breadth of experience there, right? But the incorporation doctrine started with a case called Gitlow versus New York, which was a very well-reasoned case that arose in a sedition case where someone was accused of seditious conduct. He was found guilty, by the way, but that didn't stop the court from coming up with this. For present purposes, we may and do assume that freedom of speech and the press, which are protected from the First Amendment from abridgment by Congress, are among the fundamental personal rights and liberties protected by the Due Process Clause of the 14th Amendment from impairment by the states. One sentence. So if we're looking for this well-reasoned process that takes, that looks looks like it is the product of this extremely well-developed machine. That isn't the way it works. So much of it comes out just like this. So, well, we did it once, and then later on, well, let's do it for something else. 1960, when the cops roughed up Mrs. Mapp looking for pornographic pictures inside her bra, we decided we would apply the exclusionary rule to the states. Mapp versus Ohio. So we just kind of stumbled along and did things that seemed like good ideas at the time that we did them without this experience that you talked about here as being so valuable.
Do we have time for another question? Are there any other questions?
Right here.
And there's one more.
One more.
So just like the others who came before me, I just want to thank you for this. I really appreciate this. I'm learning a lot. And I just want to start off with giving a little background to this question. So growing up in Saipan, basically, for a majority part of my life, I'm told that I should take advantage of being like a Pacific Islander. I'm a minority. People love diversity. And if I can do anything, I can bring diversity because of who I am and how I was born. But I can't help but think, is that fair? At what point is that too much? So I guess my question would be, do you believe that affirmative action policies violate the Equal Protection Clause? Or what's, in terms of fairness, what is affirmative action's place in the 14th Amendment?
That sounds like Ike's.
Okay. Well, the short answer to the question, thank you for the question. I think it's really good. The short answer to that is it's allowed. Of course, when I say that the jurisprudence, again, I'm talking about the evolving case law of the Supreme Court as it goes through these different factual scenarios throughout the years. But it was upheld by the Supreme Court, the use of affirmative action. But I believe recent decisions have limited kind of the scope of that in terms of the ability of colleges and universities to use affirmative action to admit students. And I think how you have to look at where the Supreme Court comes in actually sanctioning and approving the use of affirmative action is there's really a tension. There's a tension in the Constitution between two principles. One is what I was referring to, which is individual autonomy, which is to be judged on the basis of your individual merit, right? Because that's what ultimately the Constitution is looking for, to be sort of, I don't like to use this the word colorblind because it's been used both positively and negatively in the Supreme Court decisions. But ultimately, I think the aspiration is to have everybody's ability to succeed in America, to be determined on the basis of your individual qualifications, regardless of your race, regardless of your gender, regardless of any of these other characters and characteristics. But at the same time, I think that the other tension the courts have been grappling with is the historical reality of how the United States has come into being to where we are right now. I think the courts have not turned their a blind eye to acknowledging that in the nation's very recent history, people of color were discriminated against and were given the short end of the stick. And I think that's what the courts have allowed, and this is, sort of what I'm thinking, the basis of my advocating the use of this theory of interpreting the Constitution as a living, breathing document, right? Because it takes into account the realities of the situation. The courts have said it's okay to do that. Not to have unfettered discretion to use race as a sole measure of admitting students, right? But they can use race among a host of factors, including socioeconomic status, probably. Whether you're wealthy or whether you come, your parents have been received a college education or But the universities and educational institutions can certainly take that into consideration, and probably Dr. Underwood can speak about this more
Sure.
in his role as president of the University of Guam and how it's actually applied.
Well, you're all welcome to the University of Guam. That's my first pronouncement. But the question is really about you're trying to promote some kind of broader justice. And in the pursuit of some kind of social justice, which a legislative body or a society might try to create programs to do that, does it run afoul of equal protection of the law? So I think, I'm not going to try to be a lawyer, but I think there's a concept called, strict scrutiny, where you're trying to kind of analyze whether this kind of meets the test. So you asked a question about fairness. So fairness is really like, well, I don't know, you're getting some unfair advantage. One of the things that's regularly fascinating in the territories is all the territories get something called the Territorial Highway Fund. So Guam got $16 million last year. The Territorial Highway Fund is funded by people who live in the 50 states who pay 18 cents a gallon and the people in Guam don't pay this 18 cents a gallon, but they got $16 million last year from this fund. So is that fair to the guy at the pump in California or in Hawaii who's paying 18 cents a gallon so that you can get your Territorial Highway Fund in Guam and the Northern Marianas? Is that fair? My answer would be yes, it's fair, because, we've been treated badly, or whatever kind of reasoning we can come up with. So that absolute standard of fairness and equality is always going to be measured against trying to provide an opportunity to be, in a sense, fair in a broad way. And that tension is not going to go away. It's just not going to go away. And so every kind of public policy is going to have that element in it. Is this fair? Is it equitable? Is it promote some broader social agenda? So historically, black colleges and universities which originally were funded were segregated institutions created by the states for black people, now get disproportionate funding from the federal government because of that history of segregation. Is that fair? Well, it is in a broader sense, because you're trying to redress grievances that have been left over. When does it end? When should we bring it to an end? When do we stop it? Those are open public policy questions that we should avidly engage in.
I'm sorry, I'm going to have to bring this discussion to an end because I know there's some students that need to get to class, so we can discuss.
All right.
I know Mr. Klitzkie has more to say as to the other panelists. But on behalf of Judge Tadiko Gatewood and the District Court of Guam, I understand that there is merienda that is being offered, so I'd like to invite you to that.
All
Maybe you
right.
can speak with our panelists at that point.
Yeah, all we think, you have sandwiches and
Empanadas? We have empanadas?
Can I answer his question before we leave?
She's worried about kids needing to get to class. You can speak to him after.
I hope we've learned a lot. Great big hand to while these are very, very well-informed individuals and quite intimidated. And so we really think about having Congressman Underwood, Attorney Mike Attorney Robert Klitzkie, as our panel chosen. This is a really quite educational issue, but taking a lot of knowledge. And it is a very